Thank you. The next item of business is Stage 3 proceedings for the Contract Formation and Remedies Scotland Bill. In dealing with the amendments, members should have the bill as amended at Stage 2, that is SP Bill 76A, the marshalled list. The division bell will sound and proceedings will be suspended for around 5 minutes. If there is a division, the period of voting for the division will be 30 seconds. Members who wish to speak in the debate on the amendment should press the request to speak buttons or enter RTS in the chat as soon as Amendment 1 is called. And members should now refer to the marshalled list of amendments. And I call Amendment 1 in the name of the Minister and ask the Minister to move and to speak to Amendment 1.
Thank you, Deputy Presiding Officer. I will be brief. Section 4 of the Bill specifies what constitutes an offer. That is a proposal made to one or more persons containing sufficiently definite terms to form a contract and indicating the intention of the offerer to be bound if the offerer is accepted by the other party or parties. The current drafting refers to the person making the proposal as the proposer. In order to avoid arguments about whether the proposer could be a third party and for reasons of consistency with terms used elsewhere in the bill, my amendment number 1 would substitute the word with the word offerer, and I move Amendment 1 in my name.
Thank you, Minister. I note that no other member has sought to participate, and therefore I wonder if the Minister has anything to add by way of wind-up.
No, I don't. Thank you.
Thank you, Minister. The question is that Amendment 1 be agreed to. Are we all agreed? The Parliament is agreed. That therefore ends consideration of amendments. As members will be aware, the Presiding Officer is required under standing orders to decide whether or not, in her view, any provision of a bill relates to a protected subject matter, that is, whether it modifies the electoral system and franchise for Scottish parliamentary elections. In the case of this bill, in the Presiding Officer's view, no provision of the Contract Formation Remedies Scotland Bill relates to a protected subject matter. Therefore, the bill does not require a supermajority to be passed at Stage 3. The next item of business is a debate on motion 20943 in the name of Siobhan Brown on the Contract Formation Remedies Scotland Bill at Stage 3. I would invite those members who would wish to speak in the debate to please press the request to speak buttons, and I call on Minister Siobhan Brown to speak to and to move the motion. Up to 7 minutes, please.
Thank you, Deputy Presiding Officer. The Contract Formation Remedies Scotland Bill is a Scottish Law Commission bill that implements a number of recommendations to reform the Scots law of contract. I'd like to thank the Scottish Law Commission for its work on reviewing the Scots Law of Contract, which was a substantial piece of work which involved 4 discussion papers and a report which took the best part of 10 years. I'd also like to thank Professor Hector McQueen, who was the lead Scottish Law Commissioner responsible for the project, for his work with the Scottish Law Commission in making these recommendations, but also for his work in making these recommendations and also for his continued engagement with the Scottish Government as it has considered the SLC's recommendations. Also like to thank the Delegated Powers and Law Reform Committee convener and all the members for their scrutiny of this bill. Deputy Presiding Officer, the bill is about the formation of contracts and steps that can be taken when there is a breach of contract. Contract law is important because it affects various aspects of our everyday life, from buying a cup of coffee to significant financial transactions. Many contracts are formed and carried through by parties who have no professional assistance. One of the bill's principal purposes is to produce legal rules that are clear, certain and accessible, and it delivers on all of these. Currently, the bulk of the law of formation and remedies can be found in the common law. If enacted, this bill would put a number of important rules in a single accessible statute written in clear English with helpful explanatory notes for laypersons and legal professionals alike. At Stage 1, stakeholders and the DPLR Committee asked me to consider preparing and publishing guidance about the bill's provisions. I was pleased to write to the committee ahead of Stage 2 to confirm my intention to do so. The guidance and the bill will together help individuals and small businesses more easily understand the law on contract formation and aspects of remedies, which will help them to be better protected in any contractual negotiations. Given the variety of circumstances in which people may want to form a contract, one set of legislative rules that applies in all circumstances is unlikely to be flexible enough to cover every eventuality. Therefore, in order to ensure needed flexibility, the vast majority of the provisions in the bill are default. Parties can form a contract relying on these provisions or agree their own. This reflects the principle of party autonomy that was recognised as fundamentally important by stakeholders as well as the League Committee. Part 1 of the bill largely restates the current common law about contract formation. The main substantive reform is the abolition of the postal acceptance rule. Under this rule, a contract may be concluded without one party ever having received communication to that effect. The SLC, with stakeholder agreement, have recommended abolition of this rule for a very long time, and I'm pleased to be doing so. Part 2 of the bill deals with some remedies for breach of contract. The bill reforms part of the law on the steps that one party can take when the other party has breached their contractual obligations. Part 2 is not a full statutory statement of the law on remedies for breach of contract, but it is focused on some key areas. First, it covers circumstances where both parties have broken the terms of a contract. Second, when circumstances where a party needs to return a benefit after a contract has been terminated, for example, money or goods. And third, it brings certainty to the law by making it clear that contributory negligence is available as a defence to claims for damages based on breach of contract. At Stage 2, amendments were agreed which clarify and reform the law of contractual retention. This is a remedy designed to encourage performance of a contract without one party having to go to court to enforce it. I was pleased that the committee agreed to these amendments, which are the end point of the work undertaken by the SLC and other stakeholders such as Lorna Richardson of the University of Edinburgh. Because of these provisions, the law will now be clearer, more certain, and will help parties resolve contractual problems without the need to resort to potentially costly and protracted litigation before the courts. During earlier proceedings, questions were raised by members about protections for smaller, less legally well-informed parties. The concern seemed to be that these kind of party would be forced to enter a bargain to their detriment. I'd like to make clear that this bill does not affect consumer protection law, nor does it make changes to the unfair contract term regime for small businesses. I've committed to publishing guidance about the bill, and this will also help to protect weaker parties by ensuring they have clear, straightforward information about the law. Finally, Deputy Presiding Officer, I'd just like to mention commencement and transitional provisions for the bill. The question was raised by stakeholders and at the committee at Stage 1. There was a concern that the bill's provisions, when commenced, would apply to contracts that had already been formed. This is not the intention. While the officials will consider this in detail for commencement regulations, which is normal, my view remains that the provisions should apply only to new contracts formed after commencement. Deputy Presiding Officer, I am grateful to the committee and members for the way they have constructively engaged with me as this bill has progressed through Parliament, and for the way they have engaged with me on all the other 4 other SLC bills progressed during this session. As we now come to the end of the session, let me thank them and their clerks for their time on these bills and their careful attention to what can often be technical and legal matters. And if I could take this opportunity to note that the Deputy Convener Bill Kidd, a long-time member of the committee, is standing down from Parliament, and I wish him all the very best. Deputy Presiding Officer, I move that Parliament agrees the Contract Formation and Remedies Scotland Bill be passed. Thank you.
Thank you, Minister. I now call on Ross McCall on behalf of the Scottish Conservatives. Around 6 minutes, please.
Thank you, Deputy Presiding Officer. It gives me pleasure to speak in the Chamber today on the Stage 3 of the Contracts, Formation and Remedies Scotland Bill, and we will be supporting that at decision time later today. I often wonder if we truly take the advantage of the powers we have in this place to make substantive law that actually takes the steps towards helping people that the legislation is meant to help. We have a vast range of powers in the Scottish Parliament, and I'm not always sure that we produce good law, but in this instance, and I can wholeheartedly state that this Scottish Law Commission Bill does exactly what it says on the tin for the people that need it most. Now, as I mentioned in the Stage 1 debate, I have not had the pleasure of working on a bill that is primarily and universally supported by pretty much everybody that gave evidence. And I would like to take the opportunity again to thank everyone that participated in the evidence sessions. The additional thanks going to the clerks and staff for their hard work. And it has been a pleasure to work on a bill with the Minister, who has been, as she stated, constructive and accommodating all the way through the process, and it has been a joy. As we heard already from the Minister, the bill makes provision regarding the formation of contracts and on remedies for breach of contract. And many stakeholders have found the legal framework around contract law to be difficult to navigate, and the Scottish Law Commission's work leading up to the bill concluded that some parts of the contract law were unclear, difficult to find and in need of modernisation, and this bill rectifies that issue. As I said, the bill is universally supported. Business want it. The Federation of Small Businesses supported the bill's overall aims. And again, I'm going to repeat that Colin Borland stated, as a general principle, anything that is done to codify, simplify or clarify the law to make it easier for us as laypeople to understand has to be a good thing. And we surely can't argue with that. Also, academics, they are in agreement with the bill. Professor Stephen Bogle and Professor Tom Johnson from the University of Glasgow supported the proposed reforms when they said, considering the landscape of contemporary legislation in Scotland, it's increasingly evident that reform is needed. And lawyers want it. The Law Society of Scotland supported the proposed reforms when they stated it's clear that new statutory regime has the potential to offer benefits to certain parties by offering users a means to form agreements without a detailed understanding of case law or wider academic or institutional writings. So in layman's terms, the bill makes it easier to understand the legalities around contracts, understanding the implications of them, and, if needed, the ability to contract out. Too many times there is inequality in contracts, where one party is favoured over the other, and in certain cases, might is not always right. And given the red tape surrounding business today and the many difficulties that businesses have to cope with to survive, anything that we can do in this place to minimise bureaucracy has to be a good thing. So again, in closing, and I know I'm short on my time, but I don't have too much to add. If there was any small negative I would have in regard to this bill, it has been the length of time. I mentioned this at Stage 1. It wasn't really highlighted. I'm mentioning it again. In the Stage 1 debate, the Scottish Law Commission had been looking at issues regarding the contract law since its inception in 1965. And the recommendations were made by the Scottish Law Commission back in 2018. So now we're in 2026. So before the bill becomes an act, then I do have to ask, especially as it was such a non-contentious bill, why the heck did it take so long? Thank you.
Thank you, Ms McCall. I now call on Katie Clark on behalf of Scottish Labour. Up to 5 minutes, please.
Thank you, Presiding Officer, and I'm pleased to speak in this debate on behalf of Scottish Labour. As a member of the Delegated Powers and Law Reform Committee, I was involved in the scrutiny process of this bill, and I thank my colleagues on the committee for the work that they have done throughout this process and the stakeholders who engaged with us during the evidence sessions. The bill seeks to codify Scots contract law by introducing a statutory set of default rules on contract formation and remedies for breach. Its provisions came in response to recommendations from the Law Society, from the Scottish Law Commission, and concluded that certain parts of the current regime may be unclear for many people and that there is no single piece of legislation. The bill aims, therefore, to improve certainty and accessibility to this area of law. It is hoped that there will be no unintended consequences, and as has been said by the contributions so far, the vast majority of those who gave evidence supported the bill on the grounds it would make it simpler for lay people. Among the bill's provisions is the abolition of the postal acceptance rule, which provides that a contract is formed when an acceptance of an offer is put in the post, as opposed to when it being received. When I spoke in support of the bill at Stage 1, I welcomed that this change would allow the law to reflect the role of technological communications that we have now, but I also have to say, and this was discussed by the committee, the fact that we simply cannot rely on the Royal Mail as perhaps we could have in previous decades, in particular before it was privatised. The bill also allows for a far greater degree of flexibility by allowing parties to contract out of the proposed rules set out in the bill. The bill does not represent a radical departure from, or indeed a total transformation of, the current common law regime. It simply aims to codify what is believed to be the current law. The bill does not deal with many aspects of contract law, including the law of interpretation of contracts or the law on penalty clauses. At stage one, I highlighted that there had been a great deal of consensus on the bill's provisions, and its proposals continue to receive broad support from legal academics and business groups. As has been said, the Law Society of Scotland have welcomed the bill and believes that it will improve the law's accessibility for a range of users. The reforms are expected to improve access to justice by enabling users who may lack a high degree of familiarity with contractual agreements to best set out terms suited to their needs with relative ease and without extensive reference to case law or commentary. It was also said in the discussion around the bill that it may mean that Scots law is more attractive internationally. The main substantive amendment to the bill at stage 2 was the insertion of a section on contractual retention, which clarified when and on what terms a party to a contract can utilise retention as a remedy. The bill, as amended, confirms that a party to a contract can temporarily withhold or suspend performance of an obligation that is due to be performed under the contract in the event of a breach by the other party, in anticipation of such a breach and in relation to an obligation subsisting when the contract is ended as a result of either a breach or an anticipatory breach. We welcome this change to the bill as we believe that it serves to make general provisions of the law more accessible to individuals and small businesses, and as the Law Society of Scotland has stated, this type of remedy should be available in a flexible manner to facilitate complex transactions and contractual arrangements that Scottish financial institutions and other large Scottish business entities are routinely party to. Scottish Labour will be supporting this bill at stage 3 as we believe it represents a careful, considered and proportionate step towards modernising Scots contract law, and going forward with the hope that the Scottish Government will work closely with legal practitioners, businesses and advice services to ensure that the new statutory framework is well understood and smoothly implemented, with clear guidance, effective communications and ongoing review. And I'd like to thank everybody that's been involved in what's been a very uncontroversial piece of legislation, which I hope is successful in passing today.
Thank you, Ms Clark. And I call on Lawrence Slater on behalf of the Scottish Greens. Up to 4 minutes, please.
Thank you, Presiding Officer. Although this is a technical bill, its implications are far-reaching. Contracts underpin everyday life, from employment to housing to business. This bill seeks to modernise Scots contract law, clarifying how contracts are formed and what remedies apply when obligations are not met. Scots contract law is historically based on common law principles, which are scattered across case law and often hard to access. The Scottish Law Commission identified in its 2018 report that parts of the law were unclear, outdated and difficult to find, creating uncertainty for businesses and individuals. The reforms in this bill follow the Scottish Law Commission's recommendations and aim to provide greater certainty and accessibility. The bill introduces statutory rules on offers, acceptance, withdrawal and lapse. It also codifies remedies for breach, including restitution and valuation of benefits where no price is agreed. These changes are intended to make the law clearer and more predictable. There are questions about how these rules will interact with existing consumer protection frameworks. Consumers will still need to exercise caution when entering into contracts. Read the small print. The bill allows parties to contract out of statutory provisions. While this respects commercial freedom, some consumer advocates fear it could weaken protections for individuals in asymmetric relationships. For example, if a consumer pays for a service that never happens, but the contract says no refunds under any circumstances. Under the bill, this might be enforceable if the consumer agreed, even though the default law would allow recovery. A welcome change in this bill is the clarity on the right of retention. This bill confirms the right of a party to withhold payment when the other party is in breach.
meaning you can withhold the payment if someone doesn't do what they said they were going to do, and you then wouldn't be in breach of contract law. This was always the case, but the law has made this clearer. There are conditions and limits to this, of course. Retention only applies where obligations are reciprocal, and withholding must be proportionate to the breach. By clarifying this, the bill aims to reduce the need for court intervention, giving parties a clear legal basis for resolving disputes themselves. The Scottish Law Commission has publicly welcomed the bill as a legislative implementation of its proposed reforms. The Scottish Greens are content to support this bill at stage 3 today. Thank you.
Thank you, Ms Leaser. And I now call on Minister Siobhan Brown to wind up the debate. Up to 4 minutes, please.
Thank you very much, Deputy Presiding Officer. Can I just thank everybody who has contributed to this afternoon's debate? I've listened to what's been said today, and I'm pleased at the recognition of the importance of this bill with the valuable work that's been done by the Scottish Law Commission in keeping our law up to date. And if I could just touch on Ros McCall's point on why it's taken so long. I can't speak for the reasons why the governments back in the 70s and 90s didn't take forward contract law reform proposals, but since 2013 there has been a lot of work involving the DPLR committee and the Scottish Parliament and the Scottish Government to create a framework for quickly implementing Scottish Law Commission recommendations for law reform. There's been 10 bills that's gone through since 2013, and in this term alone, trust, judicial factors and contract law has now been passed, will hopefully be passed as well. The only older report that remains unimplemented, to my mind, is on Section 53 of title conditions. So we are making progress with the Law Commission's recommendations. Contract law is fundamentally important to our everyday life, and this bill will modernise important parts of Scots law of contract while clearing up doubts that have arisen over the years. The bill largely restates the common law on formation of contract to improve accessibility of the law and makes important reforms to clarify and modernise the law. The provisions are a result of a significant law reform project which was undertaken by the Scottish Law Commission, which included 4 discussion papers on different areas of contract law. The overwhelming majority of consultees agreed that the law needed reform. The principal reform on contract formation is the abolition of the postal acceptance rule. This has been a repeated recommendation by the SLC for over 50 years, and as Professor Hector McQueen told the committee, to abolish the postal acceptance rule without the partial codification of the law on contract formation will likely lead to less clarity. Part 2 of the bill deals with some remedies for breaches. Notably, the bill now includes a provision on the law of contractual retention. In 2018, the Scottish Law Commission said that while law of retention needs some clarification, it should be left to the courts to do so. But by 2024, though, through stakeholders, thought that the legislation was needed to bring clarity to the law. We consulted on the scheme for reform of retention, which a majority of respondents agreed with, and this came through clearly at stage 1. Amendments were brought forward at stage 2 and were agreed by the committee. Deputy Presiding Officer, let me finish again by thanking the Scottish Law Commission and Professor McQueen for this significant and comprehensive work undertaken to review the Scots law of contract and for its recommendations which has given effect to this bill. The Scottish Law Commission serves a valuable function reviewing our laws and making sure they are fit for a modern Scotland. I'd also like to thank them for the work undertaken on the other 4 SLC bills that have been introduced this session, and also for their continued engagement with the Scottish Government in taking them forward. I commend the motion in my name. Thank you.
Thank you, Minister. That concludes the debate on the Contract Formation and Remedies Scotland Bill at stage 3. There will be a brief pause before we move to the next item of business. Still allow front benches to change.